So good afternoon and welcome to the latest in our series of free webinars. As part of our AML webinar series, today we're focusing on PEPs, simplified and enhanced due diligence. So we're going to be covering what is a PEP, how does a firm know if their client is a PEP. We'll talk about the difference between simplified and enhanced due diligence, why and when simplified due diligence and enhanced due diligence are implemented. Now, the Zoom event is in webinar rather than meetings mode. This means that we can't see or hear you. You can raise your hand, of course. You can ask questions, and I'll come back to questions in just a few moments. Today's speaker is Pat Estabrook. Amongst many other roles, Pat has been a senior manager at the Legal Complaints Service. She has been head of practice standards at the SRA, where she also managed the assigned risks pool. After 11 years with the regulator, Pat moved to a private law firm as head of compliance. During her time at the firm, it tripled in size. Pat was responsible for compliance across 6 ABSs within 5 different offices, including 1 in Scotland and 1 in India. And I'm pleased that Pat left the firm to join us a couple of years ago. Pat's particular areas of expertise include SRA compliance, file reviews and complaints handling, but she also has a wealth of practical experience in law firm management, including, as you'd imagine, anti-money laundering. So I said I'd come back to questions. Please use the Q&A facility to ask questions. It's very likely that we won't have time to answer all of your queries. If that's the case, we shall, however, answer all questions after the webinar and provide you with a link to the answers. It is being recorded and we will share the recording with you as well as the slides. Okay, we'll come back to questions after the presentation. So over to you, Pat.
Thanks, David, and thank you to all of you for joining this webinar. So, as David said, we're going to have a look at the various types of client due diligence and why we have to implement them. I'm not sure who you all are, obviously, and I don't know your ages, but I vividly remember the days back in the early 90s when I worked for a law firm, when we didn't do any client due diligence. Somebody wandered into the office, we accepted who they say they were, we took their money and we did what they asked us to do. And there was none of that pesky anti-money laundering legislation interfering with what we were doing. But nowadays we have the money laundering, terrorist financing and transfer of the funds information on the payers regulations 2017 as amended. And it was amended by the 5th directive, which was introduced on the 10th of January this year, and the 6th directive, which will be coming into being on the, we hope, or we think, sometime in December, depending on what's happening with Brexit and all the other things that are going on at the moment. And the anti-money laundering legislation requires that a relevant person, which is the law firm in this case, must apply customer due diligence measures if the person, yourselves, establish a business relationship, carry out any occasional transaction that amounts to transfer of funds within the meaning of Article 3.7 of the Funds Transfer Regulations, which exceed €1,000, suspect money laundering or terrorist financing, or doubt the veracity or adequacy of documents or information previously obtained for the purpose of identification or verification. I'm never quite sure about number D, to be honest, because if you're doubting the veracity or the adequacy of the documents, I would think that you'd be very concerned about whether you're going to carry on acting for that person in any event. But so we have 3 different types of due diligence, and we're going to start with simplified client due diligence. It means that you don't have to verify the client's identity. There's a difference between identifying your client and verifying their identity. So you don't have to obtain information on the purpose or the nature of the business relationship. It's still necessary to record why you're carrying out simplified due diligence, and you'd still have to record the identity of the individual, or the name of the business, the residential, the registered address, and the dates of birth where relevant. And it's necessary to conduct ongoing monitoring during the business relationship, and we'll come back to the ongoing monitoring a little bit later. So with this simplified client due diligence, this is where this can be applied. It's a regulated financial institution that is instructing you. So if you've got a bank instructing you, you're not going to have to go away and carry out all the due diligence, the enhanced due diligence that you'd ordinarily do on a company. So public administration or a publicly owned enterprise, or a company whose securities are listed on a regulated market. Or, and this is where the area which will apply to the majority of you, the business relationship or the transaction presents a low degree of risk of money laundering and terrorist financing. So what is a high degree of risk? It's easier to look at anything that involves transactional work. So anything that's to do with conveyancing, any setting of trusts or creating of companies. They're high risk areas that you need to carry out enhanced due diligence. So if somebody's come to you and it's a PI case, it's a low risk of money laundering, unless you're setting up a PI trust that then moves into high risk. But the majority of the work that's outside of transactional work is low risk, and you just need then to obtain the identity of the individual. Standard client due diligence is also known as IDMV, which you will have seen. You have then to identify the client and you have to verify their identity. So you have to obtain acceptable documentation and check the documentation. Most firms these days have got some type of electronic verification. This is absolutely fine. You get your you can either take the original documents or you can take a copy of the documents and verify them using electronic verification. You need the full name, residential address and the date of birth of the client. And there are 2 lists which are published by the government, which we'll go through in a second. But ideally, you want the original passport or photocard driving license, plus original bills and bank statements, which have been issued within 3 months. You cannot accept a mobile phone bill because that can be anywhere. So your Group A documents are these: current valid UK passport, a valid passport of any other nationality, a valid photocard driving licence if it was issued by the DVLA in Great Britain. What I would say about the driving licence, you can also use it for the List B because it has the address on as well as the photograph, but it cannot be used for both lists. It's either A or B. A valid driving licence and the counterpart issued by the DVA in Northern Ireland, an original birth certificate issued within 12 months of birth, and a current valid UK biometric residence permit. Group B documents, there's a lot of these. So you've got building society statements, utility bills, which is what most people use, credit card statements sent to the client's current address within the last 3 months, council tax statement, mortgage statement issued within the last 12 months. And then there's P45s, P60s, the current UK driving licence. As I said, you can't use both areas. A pension or endowment or ISA statement issued in the last 12 months for a UK firearms licence with a photograph. I do actually come across some issues when I'm trying to provide verification of my own identity, because I do everything online. So a lot of the time I don't have these documents. And I have had questions from clients asking me about this, what do you do? You can see one of them is of a bank statement. I go into the bank and ask them for a copy of the statement. There's no point downloading it because it comes in an Excel format, which isn't really suitable. So I will ask the bank to print me out a bank statement, and that's the type of thing that you can ask your clients to do. So moving on to enhanced due diligence, this is where most firms seem to have some difficulty, not quite sure what is standard and what is enhanced due diligence, which area they should be carrying out their due diligence. So this is where you've assessed the client or the transactional risk as high, or you've determined them to be a PEP, or the type of work they're asking you to do is unusual, or they're in a high-risk third country. So here you're going to carry out your standard verification of your identification and verification of your client, and then you're going to also carry out source of wealth and source of fund checks, and these are different things. Okay, so your source of wealth is where has the money come from? Is it from an inheritance? Is it from their salary, investment, sale of assets? How they saving money out of their salary? Is it going into a direct into a deposit account? And if it is, you need to be looking at their current account and their deposit accounts and seeing whether the money that's showing up in their deposit account is actually coming out of their current account. Does the same amount of money go from one and flow into the other? If there's a difference, you need to ask why. Okay. Then the source of funds is the methods and means of transmission. Electronic transfers from the bank, cash deposits, checks. How are they making the payment to you? Is it coming from their bank, or is a third party paying it? If a third party is paying it, you have to carry out source of funds and source of wealth checks on the third party as well. So if you're carry out a conveyance for your client, and the deposit is coming from their mother, let's say, that's the point where you need to be carrying out the source of wealth checks and the client's due diligence on the mother or whoever else that money's come from. It's no good just saying, them saying it, you know, they're just sending it to you. You can't accept it without the checks. Enhanced due diligence can also mean seeking further verification of the client or the beneficial owner's identity, obtaining more detail on the ownership and control and structure of the client. So if it's a company, how are you going to check the control structure of the company? You're going to look at Companies House, going to look at who the directors are, but you're also going to look at the directors themselves and see who else, what other firms they're a director of, and do your due diligence by checking on whether any of those individuals are the beneficial owners of the firm. You request further information on the purpose of the retainer or the source of funds, and increase the degree and nature of the monitoring. You should, in addition to carrying out your initial client due diligence on all of your cases, you should be reviewing it at least halfway through, and then before you conclude it, before your money comes in, you should be carrying out a further review, a risk analysis to determine that nothing's changed during the course of the retainer. They haven't changed their address, they haven't changed their name, that type of thing. And if they have, you need to be asking why. From January the 10th of 2200, all obliged entities, that's yourselves, you've got to inform Companies House if there's a discrepancy between the information that you've been provided by the client and that information which is on Companies House in relation to people with significant control. You have to send that off to Companies House and inform them of that. I am asked sometimes whether there's an issue regarding this in relation to confidentiality. And the answer to that is no. The anti-money laundering legislation allows for solicitor firms to provide information relating to their clients under the anti-money laundering legislation. It's not a breach of confidentiality. So you, as a relevant person of the solicitor firm, you must apply enhanced due diligence measures in addition to customer due diligence measures under the regulations to manage and mitigate the risk arising for any case identified by one where there's a high risk of money laundering or terrorist financing, or whether you're in any business relationship or transaction where a person is established in a high-risk country. To determine whether they're in a high-risk country, you need to check the Financial Action Task Force website, and at the end of this, I have given you the website that link that you can check there. You also need to determine whether or not they're on the sanctions list, and again, I've also provided the list to that. You need to determine whether they in a relationship with a credit institution or a financial institution, and whether or not they're a PEP, or a family member of a PEP, or a close associate of a PEP. It says here, in any case where the relevant person discovers that a customer has provided false or stolen identification, you must report it. My view is if they've provided false or stolen identification documentation, I would expect that you would stop acting for that individual as well. You need to check whether your client is on the sanctions list by reviewing the HM Treasury and Office of Financial Sanctions Implementation Consolidated List. And if they are, you cannot act for them without a license from the Office of Financial Sanctions. You can't take any money for them, so you can carry on acting for them if you like, but you won't get paid. And you can't actually finalise any transaction that involves a transfer of money. So you need to check on that website. As I said before, are they in a high risk country? You need to check against the Financial Action Task Force website. Okay, so politically exposed persons. I'm asked this regularly, actually, whether somebody is a politically exposed person. I had a client ask me. They said they never actually have ever acted for a politically exposed person, but then mentioned at some point during the conversation that they'd acted for a bishop. Now, a bishop sits in the House of Lords and they have the ability to influence what's happening in this country, and therefore they are on the list. Okay, so they've been appointed by a community in an institution, a body or a state, including the UK, to a high profile position within the last 12 months. And the main aim of applying additional scrutiny to the work that's involved in dealing with work where you've been instructed by a PEP is to mitigate the risk that the proceeds of bribery and corruption could be laundered or assets otherwise stripped from their country of origin. PEPs are more, they're more liable. They're not all PEPs are open to corruption, but they are, due to their position, they are more likely to be approached in relation to trying to get them to make them more open to bribery. So this is your politically exposed persons list. It's a foreign person who's held at any time in the preceding year a prominent public function, or the same in the United Kingdom, in a state or international institution. Members of courts of auditors of the boards of central banks, ambassadors, chargé d'affaires and high-ranking officers in the armed forces, members of the administration, management, or supervisory bodies of state-owned enterprises, heads of state, heads of government, ministers and deputies or assistant ministers, members of parliament, members of the Supreme Court, Constitutional Court, or other high-level judicial bodies. And that sounds really straightforward. You know, you just ask your client, are you any of these? And the answer is yes or no. But then you come to, it extends also to relatives, close associates and beneficial owners. So relatives and close associates includes the spouse, the partner, the children and their children's spouses or partners and parents, which makes it much more difficult for individual fee earners to identify whether or not that person is a PEP. A lot of electronic verification systems these days will highlight that they are PEPs, but not all of them do, and you do need to ask the question. You're not going to know if the, let's say the daughter of your local MP's partner, with whom she's in a civil partnership, comes in to instruct you in relation to a conveyance. You're not going to know that that person actually is a PEP unless you ask the question. And there are some forms available that you can ask your clients to complete, because once they've said they're not a PEP, it turns out they are. You've got documentary evidence that they've said they're not. So beneficial owner of the person's property and somebody who enjoys the benefit of ownership, even though the title of the property is in another's name. And the example I use for this is the guy that owns Topshop. As I understand it, the majority of the shares in his property and his businesses are in his wife's name. So on the face of it, he doesn't own those businesses, but he's clearly the person who is carrying out the work and who is actually responsible for that business and the business's daily workings. So situations which might suggest you've got a PEP as a client, you receive funds in the retainer from a government account, you receive communications on official letter-headed paper, in general conversation with the client and the person, or you check your news reports, you Google them and see whether or not your client is linked to a PEP, and ask them the question as well. So in relation to beneficial owners, under Regulation 5, it's any person who exercises ultimate control over the management of a body, corporate, and any individual ultimately owns or controls more than 25% of the shares or the voting rights in the body, corporate, or an individual who controls the body, corporate. So you need to do your checks. You need to look on Companies House and see if you're being instructed by a company or an individual in relation to a company, what the percentage of share ownership is of that individual, and carry out enhanced due diligence in relation to that person. In relation to trusts, you need to be looking at the settlor, the trustee, and or the beneficiaries, and where the individual or some of the individuals benefit from the trust have not been determined. So the class of persons in whom the main interest of the trust is set up or operates. So this could be where the trust is set up and the individuals aren't necessarily named because they're under 18, and it may be that the wording of the trust is for any of the children of that person, of a person who becomes 18 on, on their 18th birthday, they're entitled to a percentage of the trust. That's the type of thing you need to be looking at. And any individual then who's got control over the trust, you need to be carrying out your enhanced due diligence when you're setting up that trust. So you need to carry out ongoing monitoring, scrutinising transactions to check that they remain consistent with what you know about the client. So you've carried out your due diligence at the beginning, and your client sits in the simplified due diligence, and that's what you've done. But throughout the course of the retainer, they change their name, and perhaps they get married. You're going to need to carry out your risk analysis again and determine whether or not you need to carry out any other type of due diligence. Does it change from being simplified to enhanced, for instance? There's a change in the beneficial ownership of a company, or they instruct you in relation to a transaction that's not consistent with your knowledge of the client. You should check your client due diligence information each time you open a matter for the client. Many firms have the same clients coming back to them over a number of years, and your policy should detail the time scale for carrying out due diligence from the time at the end of the last retainer. What you shouldn't be doing is, because your client instructed you 4 years ago and they've come back to you now thinking, well, nothing's changed, so you don't bother doing any due diligence. Your due diligence must be carried out in relation to the risk that your company has determined, and that should be in your policy. So it may be that the policy dictates that 6 months from the end of the last retainer, your client instructs you again, you carry out your risk analysis and you carry out your due diligence as well. Record keeping. Regulation 40 requires that you keep records for a minimum of 5 years at the conclusion of the retainer. So this is your file opening form, any client due diligence that you carried out. You will have printed out any documentation from Companies House, for instance. All of that will be on your file. Most solicitor firms keep it for a minimum of 6 years, because that's what's required in any event for insurance purposes. So you'll automatically meet that 5-year that 5-year timescale, but don't destroy it at the end of your retainer just because the retainer's come to an end. Leave everything that you can actually on there, on the file. So there's a number of assistance websites there that I've provided for you. You've got the Law Society. There's lots of information on the Law Society about anti-money laundering, and also on the SRA's website. There's the Financial Sanctions Consolidated List. It's I've had to give you the link like that. I can't give you the actual link. It's many pages long, and it's an Excel spreadsheet, and it's a live list, therefore it will change on a daily basis, and it doesn't just contain the specific name of the individual, it's got all their known as names as well. The Financial Action Task Force, that has a list of countries which are determined to not have their anti-money laundering processes are poor. Some that are working with Financial Action Task Force to improve them, but others don't, and they're the ones that you need to be very careful of. The Ethics Helpline option 2, they're very good actually, they will give you information about this type of thing. And then there's the legislation itself. Okay, so to summarise then, you carry out your risk assessment at the beginning of your matter, you identify the type of due diligence that's required, you apply that due diligence and you review it at the appropriate time. And then the last 3 there for me are the most important. You document what your decision is. You document when you carried out that decision, so it's dated, and you document why you carried it out. If the SRA are not happy with something that's happening, they will come to you, and what they won't accept is you saying, well, yeah, I did do the client due diligence, yeah, no. What they want to see is evidence. They want documentary evidence. And if you haven't got that documentary evidence, you're going to struggle to justify your decisions. Okay. So this was only meant to be a very short overview of the different types of due diligence, and that's what we've covered off. But if you've got any questions, you're welcome to put them to us.
Okay, thanks very much, Pat. We have got 3 questions that have come in.
Okay.
So the first question that came in was about the 6th directive. So it's just showing in the Q&A box. So the question is, I had heard that the UK government has said we are already compliant with the 6th directive and no new regulations would be implemented. So unless we are doing business in Europe, we have nothing to do. Is this right?
No. If we choose to not implement the EU's directives as they come out, the likelihood is then that we will not be able to do business with the countries within the EU. They expect all countries to comply with the EU directives that are part of the EU. Sorry, I'm waffling a little bit now. So the anti-money laundering legislation is intended to ensure that we, along with all other countries in the world that are working through the Financial Action Task Force, apply money laundering standards to prevent money laundering. And part of that is the 6th directive. Now, my understanding of the 6th directive, and I'll be honest, haven't read it in detail yet, but one of the changes that the 6th directive brings in is accountability. At the moment, if one of your fee earners doesn't report suspected money laundering to the MLRO, it's the individual fee earner that's responsible. They are the individual who will face any sanctions, which in relation to not reporting money laundering or suspecting money laundering is up to 5 years in prison. My understanding of the current situation regarding the 6th directive is that will also apply to the body that is responsible for the fee earner. So whereas at the moment there is no sanction for the firm if money laundering if there's a suspicion of money laundering, and it's only the individual, it will be the firm that's also responsible in the future. In the same way that tax avoidance is a corporate offence rather than just an individual offence. I hope that helps. Yeah,
no, absolutely. That's a good answer. So the answer was a no. So move on to the second question, which I think has come through the chat rather than Q&A. If you realise there is an issue with PSC, and I think that means person with significant control. So if you realise there is an issue with persons of significant control and let the client know first, and they update Company's House. Do you still need to update Company's House if they put the information right?
Warning, I would tell Company's House that there was a change. There's no there is no wiggle room in it in the legislation. It simply says that if there's a discrepancy with what you've been told and what's on Company's House, that you need to notify Company's House. Of course, the client can make the change as well, but just be really careful about that, because while it's highly unlikely that there's money laundering taking place, if you tell your client and it was money laundering, then you are liable to a charge of tipping off, and again, that's 5 years, up to 5 years in prison. It's all very scary, isn't it? I'm really sorry, but yeah, I would ensure that you tell Company's House that there's been a discrepancy, and then leave it to your client to determine what they want to do.
Okay, Pat. The next question covers or mentions third fault. If you come across third fault, I'll explain what it is in a moment. The question is, if we carry out onboarding through, say, third fault, and then do source of funds and wealth in all property work, that is in effect enhanced due diligence for all cases, isn't it? So third fault is a business that uses an app to digitally confirm a client's identity.
So it's an e-verification system in effect.
Yeah.
Okay. So you've verified your client's identity, you've verified your client's source of funds and your source of wealth, and you're happy that everything is fine. Then yes, that's the answer. That is yes.
Okay.
I answered that question.
Yeah, no, absolutely. And next one is, and this will probably be the last one because we're at 2:35. So let's make this the last one. I have assessed the transaction as low risk as it's litigation.
Yep.
I'm instructed by a company and I've identified the beneficial owner as one person.
Yep.
Am I carrying out enhanced due diligence?
Nope. No, it's litigation. It's not risky. From the point of view of high risk in relation to money laundering. The only issue for you there is ensuring that your bill if it's the company that's instructed you, that the bill goes to the company and not the individual owner of the company, because there you could otherwise, if he asks for the bill to go to him instead of the company, there's an issue there about avoidance of corporation tax, because you know, just need to make sure that whoever it was who instructed you is where the bill goes and where the money comes from, if possible. Yeah. Okay,
that's absolutely great. And as one delegate's pointed out, of course, litigation itself falls outside of the AML regs, which
absolutely
is absolutely right.
Yeah.
Okay, well, look, thank you everybody so much for watching this webinar. A little bit shorter than our usual format. We think it was just about right. Please do get in touch with us if you have any suggestions for topics that we haven't covered, and you'll get an email from us fairly shortly if you want to give us some feedback. Okay, so thanks again, and we'll be in touch with confirmation of the Q&As, the slides, and a link to the recording of this afternoon's webinar. Okay, see you all again soon. Thank you. Bye.